Okay, well, why don't we get started to make sure that we keep on time. Welcome to you all. Thank you all for joining. I'm Brian Heidelberger, chair of the advertising practice, wearing my spiffy coat to impress you guys. Today, we're going to talk about privacy issues in use of AI. You may have previously attended our prior webinar on this issue, and we had promised that there was going to be a follow-up on the privacy issues because they're really too complex to just handle in the general AI presentation. So that's what we're going to do today. Wanted to introduce you to each of our presenters. Jessica Lee, chair of our privacy and data security practice, Caroline Hudson, partner in both of our privacy and advertising practice, and our colleague Eric Cook as well. Today, they're going to talk you through all the ins and outs of privacy as it relates to AI. I did want to take you back to our prior webinar and just remind you, in that prior webinar, we gave you a couple different tips, strategies to mitigate risk in the AI space, such as discussing with leadership what's your goal in using AI, deciding whether you're going to be using it internally or publicly, taking a look at the actual platforms that you want to use and try to figure out how they work and how they've collected the information and trained their platform. Consider your client obligations if you're doing this type of work as an agency or vendor. And if you are an advertiser or a client, consider your goals in using the AI. Obviously, any creative output from generative AI still needs to receive standard legal review. And of course, risk questions need to get elevated to the appropriate legal contact. But as a threshold level, you might want to have a policy that AI should not be used unless approved internally as you're trying to figure things out. And that goes along with not just your employees, but freelancers and agencies considering have a policy where they have to come to you first. It's not that they can't use AI, but they have to come to you first and explain to you how they are going to use it before they proceed. So if you missed that prior webinar where we detail how AI is implemented in advertising, marketing, and entertainment, feel free to reach out and hear about all of these steps in detail. We had it recorded and we can forward that to you. Right now, I'm going to turn it over, I think, to Jessica to dive in on the privacy issues.
Thanks, Brian, and thanks everyone for joining us today. If we look over, I'll just go quickly through our agenda and what we plan to cover because we have a lot to get through. But we thought we'd do some level setting because we hear AI gets tossed around a lot. And it's kind of like a placeholder for a number of different technologies. And I think it's important, particularly from legal teams, to understand, specifically what are we talking about so you can, identify the risks and manage them. And then we'll talk about, what does privacy look like in the age of AI? There's been a lot of conversation. Obviously, we're talking about artificial intelligence. There are IP issues. There are liability issues. Like, where does privacy? Why is privacy, always part of this conversation? So we'll talk about where those issues lie. And then we'll go into some of the regulatory frameworks. It's, a real patchwork right now. So we're seeing, guidance getting put out by agencies reminding us that the old laws exist, even applying to new technology, even though that might be complicated. There are proposals for new laws. And then internationally, obviously, there's a robust amount of legislation happening as well. So we'll kind of walk through that. And then, we like to end these sessions with, practical strategies, like what should you do next? And then we'll talk about the ethical considerations. And if there are questions, we'll try to get to them. Even though I said we have a packed agenda, try to put them into the Q&A and we'll get to them as we can. So let's dive into just kind of quickly defining artificial intelligence. So, basics, very basic, in AI, this is not new. There's a lot of conversation because the speed of adoption and the rate of adoption has been so high, particularly, this year, with ChatGPT and DALL-E and some of the generative AI uses, but we've been talking about some version of artificial intelligence for decades, actually, right? So at the basics, this is the computerized ability to perform tasks that are commonly associated with human intelligence. So that's, reasoning, discovering patterns, and that sort of thing. Usually these responses and the outcomes are based on math and probabilities, right? Not on actual, cognitive behavior. And that's at the foundation. And as artificial intelligence escalates and gets more mature, we get to machine learning. So, improving through experiences, learning on experiences. We have generative AI, which is kind of the hot topic and what has, caused a lot of people probably to come to the table today. These are techniques that train models on existing data and then can generate new content, right? And I think this will tie heavily into our conversation on privacy because, as AI, requires data, obviously, and all sorts of data. Some of that's personal information and some of that's not. But as it gets more mature, it requires, ingesting these large volumes of data and being able to process them to generate new information. And then, again, it's getting more sophisticated farther out there. We're talking about neural networks and deep learning. And this is where I think you get a lot of the hype and concern about, AI taking over, being able to learn for itself and think for itself, kind of being initially programmed and fueled by data powered by humans, but getting to the place where it, I'll say lives and breathes on its own. So this is kind of the scale we're talking about here. So if we go to the next slide, just to give some examples of AI in action. And this is the Future of Privacy Forum has done a lot of work in this space and has put out just some examples of what we're seeing. I won't go through all of these, but a couple to highlight. In particular, and this will come up in some of the regulation we're talking about, is we're seeing a lot of adoption in the workplace space, so workplace monitoring. I heard from someone a couple of days ago about in China using brain caps to measure brain waves to identify when employees are experiencing fatigue at minimum, but also monitoring things like productivity and how tools and how their jobs are being performed. That's scary town. I think what we're seeing right now. More relevantly is just kind of general workplace monitoring, device management, monitoring employees for efficiency. We're seeing there been tools used for if you have truckers or drivers, if you're shipping products, to monitor their productivity, make sure they're staying awake and seeing how they're performing. So a lot in the workplace monitoring space, and I think that's why we're seeing a lot of regulation there as well. And then a couple of other things I'll point out, obviously, big impact in the healthcare space. And then also in content moderation. But if we go to the next slide, this is from a couple of years ago, we're seeing this escalate even further. So AI is embedded in technology like chatbots, for example, augmented reality and virtual reality. So a lot of the metaverse is getting powered by different versions of artificial intelligence, content generation platforms. One other note not on the screen that I'll point out that I heard about recently was Karen.io, which is an AI-powered tool that was created by someone who lost their father. And the idea was that you could use AI voice, a synthetic voice that would mimic his father's speech using artificial intelligence and deep learning, so he could continue to have conversations with his father after he passed away, which was literally a basis of a Black Mirror episode. And it started with that, and there's potential, and we'll get into the ethics later, which that becomes very relevant there. But the commercial use, or adopting that technology for commercial use for influencers, so that help influencers replicate themselves and expand their voice and ability to reach and contact their followers. So, a wide spectrum of where we could see, AI in action that has business and commercial impacts, but has societal impacts as well. So if we go to the next slide, the other direction, there are obviously some, great benefits and drawbacks here. So, on the benefit side and some of the use cases we saw, the ability to use AI, for example, in healthcare, and even though, there are probably ethical concerns in the workplace, significant benefits there as well. The ability to really, automate manual tasks, particularly tasks that can be dangerous to workers, to free them up for more skilled behavior. You can augment your limited data with synthetic data, particularly for those of us in the privacy space, with privacy regulations becoming heavier in the US and access to data getting more challenging. A lot of companies are turning to synthetic data sets as alternatives, but you need to have some baseline, some underlying data to power that. simulations, personalized content, customer service, solving complex problems. The benefits are really innumerable, but those are obviously have to be balanced, and we have to think about what some of the drawbacks are, what some of the risks are, right? So things like misinformation and fraud, the idea that AI is infallible, right? That it should, if it gives an answer, we should assume that answer is correct. If it makes a decision, we should assume that answer is correct, that decision is correct because it's, unbiased and objective. That's really wrong, obviously, because it's built on existing data and it builds in bias, right? And we'll talk a little bit about some of that. So you can't just trust AI blindly, which is what I think the inclination might be to do. And then on the legal side, obviously intellectual property issues, we'll talk about the privacy concerns, who's liable, particularly when we get to more sophisticated versions of neural networks, and then, some of the ethics. So, these are some of the things we have to balance here. So with that level setting, I think we can jump into some of the privacy questions. So what does, privacy look like in the age of AI? And there have been a lot of headlines on this, human extinction, looking at things like Clearview AI's use of facial recognition data, particularly powering that to law enforcement. We saw earlier, I mentioned ChatGPT and the reaction from EU regulators citing data protection concerns, and some of that is starting to be addressed, but there have been a lot of headlines about this. But then there have been some, counterbalancing viewpoints of like, why are we even talking about privacy? Again, there's a lot of data, but not all of it's personal information. So, where does privacy actually have a role when we're talking about the use of these tools? So if we go to the next slide, I can answer that question for you. So, how does privacy intersect? Well, first, again, because you will have personal information. If a lot of these tools, particularly the generative AI tools, are scraping, all sorts of publicly available online sources for information, inevitably that's going to contain some element of personal information. So you have to understand, what is the source of the data? If it relates to a specific person, there will be privacy rights that attach to that. In the EU, that's clear. In the US, we have this patchwork, but there are still laws that apply. And you can't just think, well, it's publicly available information. Again, there still might be restrictions on that. And then when you go to, data use, again, because some of that underlying data is personal information, privacy laws will apply to that. And we're seeing, kind of following off of the EU model, and we'll get into more detail on this, but there's always been this concept of automated decision-making baked into EU regulation and starting to get imported into the US as well. So if you're using personal information to make automated decisions that don't have a heavy amount of human intervention, or you're using it for profiling, or you're using it in high-risk areas, there are additional obligations that attach to that, whether that's doing, impact assessments, whether that's giving consumers the right to opt out of that. So you need to think about, okay, well, if the data set I'm using is trained on personal information's impact.
I think it looks like Jessica maybe froze for me. Eric, can you nod if she did the same for you? Okay. So hopefully Jessica will be back with us in just a minute. But I think to pick up where she was leaving off on this slide, I think
So you have cadence of interacting with you have a cadence of interacting with your with your business teams and identifying risks in their products, and that can now be adapted for use in the AI cycle. So using your existing privacy program to establish responsibility policies and accountabilities, using those impact assessments, and kind of importing that model, I think, into the AI space is what we're seeing going forward. So if we go to the next slide. So just to recap, some of the privacy challenges will have existing regulation. So I think more and more, like I mentioned, the automated decision making, we'll start to see AI concepts baked into new privacy regulation. So that's going to be part of your privacy obligations. And things like, data minimization, requiring transparency, requiring consumer control, all of that is going to be layered on top of or privacy challenges you'll have to consider in the use of AI. I think particularly like the user's lack of control and how to provide transparency are where we see a lot of friction, and we need to sort of solve for some of that. And then on the outskirts of some of these challenges are things like, bias bias and manipulation, which I think of as privacy adjacent, but they have a human impact because human data is involved. So I think that's a pretty good baseline to set. Let me turn it over to Eric to jump into what the specific regulations look like here.
Thank you, Jessica. I'm going to be discussing the current and future landscape, and we wanted to start off with the frameworks. First and foremost, none of the frameworks are required by law at this point. Each one in many ways kind of builds on what has been existing probably for, I would say, the last 3 to 5 years and they have a pretty consistent framework between all of them. And they're more out there than this, but each framework kind of consistently asks businesses to consider the reliability and the validity of the actual AI system they're using. So basically, does it do what it says it's doing? Is it fair and free from bias? Is it transparent and accountable? Is it secure? And then there's not a single framework that does not include privacy. And in many ways, privacy goes throughout each one of these items because of the idea that this data is being collected from individuals. I wanted to point out a couple of specific between NIST, the AI Bill of Rights, the Better Business Bureau's recent regulation, and Singapore's AI governance framework. So with NIST, it's a voluntary framework to assist organizations with their building of the AI systems. But what makes this one a little bit different is obviously there's a framework for privacy that NIST has already created, and there's also one for security. You could argue that if you've already built systems off of these particular frameworks, then this one will be easier for you to use because you can go and look at NIST and basically doing a breakdown of how to move through and navigate the building of your AI system to those goals that I mentioned before: reliability, fairness, free from bias. The AI Bill of Rights, which was published in October 2022, is kind of the initial kind of focus from the government when it was issued, has some specifics on data privacy that I think are particularly important, because when it focuses on, it goes through these same exact levels of safety, effectiveness. But on the data privacy side, there's a portion where it says there needs to be an enhanced and there should be emphasis on enhanced protections for sensitive information, and actually lists out those pieces of sensitive information pertaining to health, work, education, criminal justice, finance, and children, and should include an ethical review. So a board that potentially is reviewing these particular sensitive use cases and the data that's going into them to be used, as well as use prohibitions. The Better Business Bureau's Principles for Trustworthy AI on Recruiting is exactly what it says. It's specific to workers and kind of builds on these same exact principles. And then what's unique about Singapore's AI governance framework is actually it uses all these existing kind of principles, but actually has 11. I will not list them out, but it mainly is using these particular 11 principles with the overarching focus on a more human-centric kind of focus and way of going about AI governance. And you can advance to the next slide for me. At this point, it's kind of interesting to have this, given that there's no kind of like overarching AI focused law in many ways. There are plenty of these laws that touch AI because they're touching the data. But we're just now starting to see these laws that are focused specifically to AI and mainly in the workplace. You can advance to the next slide for me. And so the biggest one, we want to talk to is kind of the elephant in the room is the EU AI Act, which at least how I would consider the only true broad AI legislation. The EU Parliament actually voted yesterday to advance and move forward with this draft legislation with the intent on having this completely enacted by the end of the year. And when I say that, just the legislation passing by the end of the year. Unlike some of the other AI-focused regulations, the General Data Protection Regulation, California's Consumer Privacy Act, and the other, at this point, 9 state privacy laws, all have a focus more particularly in the instance that they're mainly regulating the data. Each has a specific right that allows consumers to opt out of the use of their information for automatic processing or automated processing. So obviously that's going to have an implication for AI. But then just more generally, these laws impact on actual consumer data, and the consumer rights that they get as a result are going to be what's really important. And then I want to draw your attention to New York's AI hiring tool regulation that is focused specifically on the use of AI tools and AI systems that enforcement will begin July 5th, so just the day after 4th of July this year. And it's focused particularly on these AI tools, Illinois' Artificial Intelligence Video Interview Act. What's common among these, one is that both of them are focused on workers, but both require that notice be given and consent be obtained before using them. New York in particular requires an annual bias audit. So basically comparing the differences in, how many individuals of a particular race or age are actually being hired, and then subsequently in comparison to the general pool as a way to determine whether or not there's some form of bias in selection. We can advance to the next slide. Next, we have, and I said broadly because the FTC has made it clear that they intend to use existing laws to enforce AI at this point. And the bigger one to focus on for us is Section 5, which prohibits unfair and deceptive practices. A good example of this in particular for us would be Ever album, which I believe is 2 years old at this point, that has a specific focus where the FTC basically said, hey, this particular data it was a photo sharing app. So it basically was using the photos, ingesting into their facial recognition algorithm, using that algorithm then for their basic service, kind of increasing its ability. But the problem was they had told people via notice, consumers that were using this particular album, that it would not be used. Their data would not be used in this facial recognition. And so it never obtained consent. And the more scary part of this was, as a result, the FTC and its decision required them to delete not only that data, but the algorithm itself. So as a result, we lost the data, lost what I believe would be a lot of investment into the algorithm moving forward. I'll touch base a little bit more on the FCRA and Equal Credit Opportunity Act, but these are both ones that are tools at the FTC's disposal that they also will be using in particular like industries and, as indicated, employment, housing, credit, insurance, and benefits. But these are particular areas for FTC enforcement. We can move to the next slide. As indicated, all the state privacy laws are going to have an impact. And I think what's most important to think about in the instance of the states is that their impact is going to be specific, not only just to AI in the instance that you'll have the right, that consumers will have the right to opt out of those automated decisions, but also the very instance that this is going to go into that prong of accountability and transparency, because once the system is created, it's going to need to already have embedded in it the ability for consumers to exercise their rights. So exercising their right to access that data, correct that data, delete that data. All those rights are going to need to be embedded in the AI system. And obviously, as we are kind of learning, that's hard to do once that data is fed into that algorithm. So it's very important that this is considered at the outset as we move forward through the system. A particular focus on California, who will be issuing regulations of automated decision-making soon. They originally had an invitation for preliminary comments. I believe it's on February 10th, and that has closed at the March 27th of this year. So I'd imagine anytime soon we might go ahead and see those regulations with a good spell out of what is going to be required for automated decision-making moving forward, at least for California consumers. We can move to the next slide. Kind of further with the issue of the impacts on state privacy laws, we wanted to kind of narrow this down to what those important issues are going to be. Beat it like a nail, right? And the right to opt out of this automated decision-making and profiling. And it's not unique to just the states. It also exists with GDPR. But more importantly, risk assessments. Every state privacy law at this point has some form of requirement for risk assessments or data impact assessments for just the privacy portion, and whether or not specifically in instances where things are high risk. And so we're going to think of mainly protected class, such as race, age, ethnicity, gender. But also, as you're kind of going to constantly see throughout this, is issues specifically with the AI Bill of Rights, instances where we're talking about specific industries. So health, finance, insurance. Another issue that needs to always be focused on is when you're placing the notice out to originally obtain that data in the privacy context, once it's being fed into the algorithm, you might be now using that for a different purpose. And that may require separate consent. So always kind of considering the context in which the data was originally received, and now later on, what might that data be used for because of that subsequent need for consent. And then finally, the data governance controls specific to de-identified data. You see this more so in the healthcare context, but you see it generally where this data is de-identified, but many of these state privacy laws have additional requirements. I know in California in particular, the notice has to make sure, not only will you have to have contractual kind of restrictions when you are transferring this data to service providers or other vendors, but this data and how it's being used in a de-identified form, you will have to potentially have this in your actual privacy policy, how this is being used in a particular, I think in California proclamation, that you will not be using it beyond those particular purposes. And we can advance to the next slide. Finally, we want to give you kind of a couple of examples in the particular sectors. So the EEOC provided some guidance regarding the use of algorithmic decision tools, and specifically what they define as selection procedures. So when you're using an algorithmic decision-making tool in the selection, so in the hiring, so hiring, promoting, terminating, similar actions are clearly regulated under Title VII. And so you will have that kind of overview as an issue that needs to be considered in the employment context. And what you're seeing, at least at this phase, is consistently a lot of these laws have thus far focused particularly on the workers' context. In health, it's been more tackled with the FDA to the extent that the FDA has basically said that instances where a particular software or AI system qualifies as software, it'll be governed under their medical device requirements. There are instances where it might not be governed, and we see that in instances where it's like general fitness and items that were considered more low risk. When it comes to HIPAA in particular, the privacy and security rule of HIPAA will apply very much the same way the state privacy laws apply. It applies to instances where you're dealing with protected health information specifically. Obviously, this one is in the news a lot lately, but with protected health information. And then finally, wanted to give a little bit of background with regard to the financial services sector with FINRA and CFPB. There's a particular example focused on chatbots, and that the use of chatbots have become, quite frankly, confusing to consumers that are using this. There's a lot of statistics about how these chatbots are being used with consumers in just general banking and in fintech. And as a result, I think the issuing guidance was just to let the businesses know and let individuals know that these particular anti-discrimination laws will apply irregardless of the particular system that's being used. And so that as businesses will still need to consider protected class in these special circumstances and the potential impact they have on individuals in those protected classes, as the Equal Credit Opportunity Act will still apply to that AI system. And then finally, the investment advisors is specifically focused on the duty of care situation. And we can advance to the next slide. I believe I am handing this one off.
Yeah, thank you, Eric. So I'm going to take over for a little bit. We talked through the various laws and guidance that we've seen it come out, especially recently. And so to finish up this kind of overview portion of the regulatory landscape, we also wanted to touch on just a couple of other issues that sometimes come up when thinking through some of the initial or even some of the more basic questions around AI. So one is around whether there are ways to manage some of the compliance obligations under state laws and other laws by limiting the amount of personal data that an AI system or tool might have access to, and instead using de-identified data or anonymized data. So if it's personal identifiers that can lead to misuse or unexpected uses of data or possibly re-identification of people, maybe let's strip some of that information out. And voila, problem solved. That that can theoretically be possible in some use cases, but there are sometimes a couple of issues with this as a solution. One issue or one of the trade-offs that comes with removing some personal identifiers is that it may make the data less useful for training and learning. So it might be less good at training or improving the model. The other issue is that, de-identification and anonymization are terms people use a lot, and they are options in theory. They can also be really difficult to implement in practice. So there's a few examples on this slide of ways in which re-identification of individual people can be possible even where you might not expect it. So you could, for example, take millions of anonymized taxi trips, combine them with Google Images, and suddenly figure out which taxis had celebrities in them and where they were going and even how much they paid. Things like a 5-digit zip code combined with a birth date and a gender can reportedly let you uniquely identify 85% of the American population, like uniquely identifying each one. If you add a few more characteristics like age or marital status, you can get to a point where you can re-identify something like 99% of Americans. So even this kind of anonymized data can be combined with other data and get you back to a person. And you can kind of see how AI solutions combining multiple de-identified data sets, you may end up right back where you started with identifiable individuals and personal data. And the FTC cares about this possibility of re-identification too, and they've cited the fact that third parties can combine multiple, what might be a de-identified piece of data, that they can combine those identifiers and use matching services and get back to an individual or to personal data. Another issue that comes up in some of the initial stages is sensitive data or sensitive personal information. One of the cautions around AI solutions is often this idea that you can avoid problems if you just don't give sensitive data to ChatGPT. Leave out the sensitive data and you'll be fine. I think it's worth at least emphasizing that clearly the tenor of our conversation so far has been that there are requirements that apply beyond just that sensitive data category. They apply to personal data generally, that there is more that we need to consider. And I think it's also worth emphasizing that the way that we've thought about sensitive data, or the definition of what is sensitive, is really continuing to expand in many ways. So we're not just looking at the pie chart on the left, but all the things on the list on the right as well, when we look across the different state comprehensive privacy laws and health data laws in particular. So health data especially is an area where we're seeing new laws and broader definitions for what falls into that category. And with this sort of expanded definition of sensitive data and expanded definitions of health data come more high-risk systems, more relatively higher risk applications. So in general, the areas we've listed on this slide, like employment and housing, insurance, finance, healthcare, security, it's not to say that you can't use AI tools in these circumstances, but these are just areas that are going to be out in front when it comes to places we're seeing the highest scrutiny, really, around using AI and those types of solutions. That tracks with what Eric described when he talked about the sector-specific guidance. That guidance is focused on things like algorithmic decision-making and hiring and promotions and firing, denying credit, investment advice. So more regulation, guidance, and scrutiny in these areas turns them into higher risk applications and higher risk AI systems. And we raise all this, I think, just to try to outline some of the key concepts and definitions and regulatory schemes. And so at this point, we want to take that baseline and kind of lean on it to talk through how, from a practical standpoint, you can try to get ahead of and mitigate some privacy risks from a legal standpoint when it comes to using AI. Before we do that, though, I have the extremely important task of reading out the CLE code. So the CLE code for our session today is here on the slide, and it's PAI 615. That's P as in privacy, A as in artificial, and I as in intelligence. And today's date is 615. So I am going to have to move off this slide now, but please don't panic. We will make sure to repeat this at the end of the presentation. And like I said, we want to make sure you come away from this session with some practical strategies. So we're going to turn now to sort of walking through really the analysis and the steps you might use from a privacy perspective as you're thinking about maybe one particular use case for AI for your business. And I think a lot of this starts with thinking about and leveraging the concept of privacy by design and using that sort of step-by-step process to think through and think about these issues. So when we talk about privacy by design, we're talking about and using this idea of building in privacy considerations from the start of a project as part of the development process and early in that development cycle, as early as we can get it in there. And this is a model regulators have been pushing for, and we'd suggest it's a model that works well for AI tools and applications and systems too, from a privacy standpoint. So like with other privacy reviews, you start by thinking about mapping out the data that you want to use, what it is and where it's coming from, and your various data sources. And those might be similar to your usual data categories or data sources, or they might be very different. You might be thinking more about data that's coming from public sources or data that is de-identified or that's meant to be de-identified. And you'll also want to think about some of the high-risk systems and applications that we just talked about, say in the employment and finance and housing and health spaces, and kind of identify those if those are in scope from the get-go. You'll want to think especially hard about how you can embed user rights into some of these AI systems. That part can be particularly challenging given the really opaque ways in which some of these AI systems function, particularly when they're provided to you by third parties. And then you move through factoring how you'll provide security. This can be really critical. I think we're increasingly hearing in our space that the big AI risks fall on the privacy side and on the security side. It's, are we respecting privacy? And is there a chance that this is opening us up to a different type of security incident? So this is another way in which you could see security issues. And then you look at how you'll test the outcomes. Did it work? We tried to account for all this stuff, and did we? And then how do we go about giving notice to people of what's happening and what we're doing, and how this all is going to work? You know, maybe you're working on a new product and your business teams have brought it to you and there's an AI integration or an AI component to it in some way, shape, or form. You know, your existing product review processes and cycles can help here too, and they may also layer on fairly well. So even though AI feels really new, you know, accounting for it and some of the nuance that it adds can be built into some of the existing ways and existing things you use to guide your business teams and your clients. And again, you start by understanding the data flows, what's coming in, what kind of data, you know, where is it coming from, where does it go, who is it about, how do we keep a handle on all of that? Another important point, I think, is whether there are vendors or service providers involved in this particular project or this product, and sort of what aspects of AI those vendors touch or provide to you. I know Jessica's going to dive into this more deeply later when we talk about sort of executing on all of this. And finally, you can figure out what controls you need and implement those to try to address all these privacy, security, and regulatory risks. You know, one other key aspect of really any review for anything AI related is it's really going to be factoring in and thinking through the possibility of bias, both in the data sets and in content going into an AI system and in the output coming out. So I'm going to hand it back to Eric to do more of a deeper dive for us on that piece of this.
Thank you, Caroline. So, you know, understanding the risk for bias, this is something at this point that we're constantly seeing and hearing. And I think the best way to think about it is there's the kind of apparent data that most of us are trying to avoid putting in directly unless necessary, which usually surrounds race, religion, sex. But I think what's most important, or at least what we're seeing most, is whether or not there's an impact that we are unaware of, and whether or not that impact is happening on the tail end with the outcomes, such as race, religion, and sex. One particular indication of this where people aren't always thinking about it is the ADA. So the EEOC also put out guidance about whether or not the potential for the impact in the workers' context would relate to individuals with disabilities. And those who might not be able to actually access the web or be able to view it in the same way. So that's an issue that needs to be considered. So we always have to consider the impact. Next, we need to consider how robust that data set is. Does it include all the individuals it should include? In many ways, you're kind of looking at this kind of like a scientific method argument. Is there enough data here that's representative of the population? And then finally, is the data uncovering based on the data that's being used? Is it basically uncovering an existing kind of status or way of doing things? And the constant example using the healthcare context is systemic racism and the inequities to healthcare access. We can switch to the next slide. And so, very consistently, we're seeing this happen all the time. But, the question is, how does this happen? I think the common, and now we're getting taught to this, is that there's bias training data. Are we using just a simple set of data to train this? The other one is faulty assumptions. Are we assuming that some of the data we have is representative or the particular outcome we're looking for? The common one that, quite frankly, shouldn't be unique to AI at this point is diverse teams. And then finally, actually reviewing the outcomes of these. It's going to be required, and it looks like it's required for every AI system, at least from the worker's point of view at this point, from that particular legal standpoint. But via the risk assessments, this is where you're going to be needing to do these audits and assessing and determining to what extent this impact basically is having an impact on these particular groups, and quite frankly, in particular industries where you're going to want to make sure that, for instance, like I said, in finance or healthcare, that this is not impacting certain groups differently than others. You can advance to the next slide. In many ways, once again, this is, I think, the biggest thing to pay attention to is the data source, but also kind of cross-checking how this data has been labeled and whether or not, this is not just one individual necessarily labeling this data set as it's being trained, as you're using it to train this particular algorithm. Having individuals kind of review it. We've already kind of seen quite a few examples of this where individuals are having one group label it or another group label it. And the typical biases we have as individuals don't go away necessarily because we're, using the algorithm. We're the ones inputting the data. And so having different individuals do so and making sure ultimately that the outcome we're looking for from this particular set of data and all that kind of combined is actually assisting us in the outcome we're looking for in order to mitigate bias. Because you're seeing, particularly with all of the regulations, whether it's the AI Bill of Rights, NIST, Singapore's AI governance, and all the laws at this point, a particular focus obviously on bias at this point and making sure that it's not in these systems. I believe I am turning it back.
Yes. So, just to kind of wrap up and think about how we put a program together for AI governance. And Eric alluded to this as well in terms of having, stakeholders, potentially having a council. We've seen different variations of this at different companies who are thinking about, how do we bring in and kind of what I talked about at the top, all the key stakeholders, right? The people involved in insurance, people involved in finance, people involved in litigation, IP, privacy. This is a multi-stakeholder group. But ultimately, we want to think about who is going to be and engineers. Sorry, you cannot have this conversation without mentioning that the engineers obviously need to be at the table and your data scientists. But we need to think about who's going to be responsible for what, who is going to be, actually accountable, and who needs to be consulted and informed. And this is important because you need to have checks throughout the AI life cycle, and that is in the initial development. In the fine tuning, and then when it gets deployed, you need to go out into the world. There've been numerous examples of even something silly like a chat bot being released on Twitter and it having negative impacts. You need to have someone there who can monitor the outcome of whatever you've put out into the world, so it can be dialed back, adjusted, modified as needed, or maybe it's perfect and it can just go out into the world. But you need to, the review process doesn't end when something gets released. So thinking about how to establish accountability so everyone knows what their roles are, and then whose budget line does this sit on, who's ultimately responsible, not just from a governance perspective, but from a financial perspective. So if we move to the next slide, so what does it look like now to finally execute? So some of the key things you want to do is, to have policies and procedures to operationalize the system management. Does that look like, again, a system of checkpoints, for example, along the AI lifecycle? Does it have guardrails for, what you can and cannot do? Like, how much freedom do you give your teams to run and innovate, which you're going to want to do, but how do you create guardrails so that they know when to come to you? Or if you're dealing in a highly regulated space, maybe there can't be a lot of freedom. Maybe there have to be, checkpoints and constant feedback along the way because of how sensitive or important the data is or the systems that they're building. And obviously for every company, this is going to be different, and so in that is going to be baked this cadence of regular review. And then, the key for this, and this kind of ties back to, the context of AI for privacy, is aligning your external statements with your internal practices. So, a key piece, obviously, if you're on this call, you're aware, I'm not saying anything surprising. Transparency. How do we explain, to the world, to our consumers, to regulators, to the impacted populations, what we're doing with their data, how it's being used, and what their rights look like. And if you're not having the appropriate conversations internally, you can't align those external statements. You can't provide that explainability and that transparency because you don't have all the information, or you might, misstate something. And if we go back to, the slides on regulation, particularly for the US, at least for right now, deception under, the FTC's Section 5 authority is going to be one of the key places where we see a lot of regulation come up. So the thing did something different than what we said it was going to do, or there was some outcome that was different, or some promise that we broke. And so that last bullet point, I think, is particularly crucial. So if we go to the next slide. Oh, and I'll just say, sorry, before I get into consumer rights, I also wanted to just mention the vendor management piece. So, and Caroline alluded to this, for a lot of companies, you're not doing all of this yourself, right? You're engaging vendors. So that might be, to supply the data, that might be, on the programming and deployment side. And you want to understand, well, first, obviously, what they're doing, what kind of assessments you can provide, particularly for your data sources, what is their source of data, even if they can't give you specifics because they want to have some, that might be considered proprietary by them, but you want to understand what is their legal basis for being able to give you access to this data, what restrictions do you have on it potentially, what kind of assurances can you get, what kind of warranties can you get. And this is, a conversation for a completely different webinar, but the insurance market is changing. So, it can't just be relying on reps and warranties and indemnification, because they might not have, particularly for smaller companies that you might be working with, the insurance policies behind them to give you the protection that you need. So kind of really digging into how do you vet your vendors, and then how do you ensure that your agreements are tight enough to give you protection, and is there anything else like insurance, et cetera, that you can layer on top of it. And one thing that we are seeing in a lot of these new privacy laws, particularly in the US, are these obligations, not just to have this paper exercise of having an agreement, but then to also audit. So to the extent you're providing a vendor with data to build something for you, and you put restrictions on how that can be used, what mechanisms do you have in place to actually audit that they're doing the thing that they said they would do? So I wanted to flag that before we move on to the consumer rights. So of course, incorporating consumer rights, both for the transparency side, but just because it's required by law, and really thinking through. And again, this is why I mentioned, did not want to forget having the engineers of the team, because a lot of this, once the ingredients are baked in, it's like you can't pull just like the butter out of a cake once it's baked, right? Like, how do you figure out, how do you pull out one individual's piece of information? How do you offer the right to correct or delete, to opt out? What does that look like, and what are the limitations? So I think it involves having a real conversation about understanding how your data architecture is structured, and what are the limits on what you can do, and what can you put around that, right? Can you make an argument that the data is de-identified after a particular point, or there are other guardrails you can put in place? So it really requires, I think, getting into the weeds, maybe in more than other areas, to understand specifically how that data is being stored and managed, to understand what you can be able to do, so you can again align your external statements with what's happening internally. And then of course, consumers should have some right, and we saw this coming out of ChatGPT's response to the Italian DPA's what's the word I'm looking for? Short-term ban. That's the word I'll look for. It was, I don't want to say ban because it technically wasn't banned. It was just sort of suspended for a little bit to make some updates. But one of the things was, how do you start to update data? How do you start to correct misinformation? We're starting to see defamation claims come out because personal information is being displayed or generated in a way that is false. So how do you provide consumers those right to correct and update? And then we're talking about specific harms, right? We're talking about outcomes, whether it's in the employee context or health or other contexts, they're higher risks. How do you address that? And how do you can use potentially consumer rights to try to detect those behaviors? So if we go to the next slide. So this is just an overview. I'm not going to go read all of this, but wanted to give an overview of the AI review life cycle. I think you take what we see from the NIST guidelines, you take what's already in place from, privacy impact assessments and maybe pre-existing data governance, and you take what's like maybe a little bit more specific to AI, and you start to see, similar threads or flavors of what companies are doing and how they're building this out. And you can look to companies who have talked about this very publicly, like IBM and Microsoft, who have put out good standards, but there are some general themes in terms of the AI review life cycle, right? So from the beginning, from the acquisition piece, understanding the source of the data and doing things like where can we minimize? Do we have an opportunity to minimize the amount of data collected? Do we have the opportunity to de-identify? Are we getting sensitive information in? How do we start to protect that? What kind of security do we have in place? So from an acquisition perspective, how are we onboarding data, making sure we're ingesting clean data? Once it's in, what are the use cases? How are we processing it? Again, what checks can we make sure that we're using the data in a way that's consistent with its intended purpose and consistent with the purpose that has been approved internally, but also disclosed externally, so that we can be transparent. And what opportunities do we have to insert some level of human review at some point, in a way that doesn't frustrate the purpose, right? Again, the goal is to help innovate, but to protect the company. And then once it goes out, the dissemination, you want to account for how you might have some bias or inequities. Bias in particular has been, I think, one of the critical issues outside of some of the IP and privacy issues that there's been a lot of concern about with AI. So how do you start to, try to detect that? If you haven't detected it in the earlier part of the life cycle process, how do you detect it, at the end again? And how do you start to do audits? I think there was a Chambers report, I think back in March, and they interviewed like 100 stakeholders about what the US should do in terms of AI regulation. And the theme of the thread through that seemed to be that we'll do what the US did with privacy, which is it will regulate the specific harms in specific areas, but there seemed to be a hesitation in having broad-based regulation, kind of like the EU AI Act, because it would stifle innovation. And so you'd have maybe something like what they called soft law or regulation, kind of around the edges. And so I think for some companies, while we're waiting for, you're not going to have necessarily, at least in the near term, a black and white, you can do this or you can't do that. And I think having, documentation and audits and assessment for both internal purposes, so you can remember what happened and why decisions were made, but to the extent there are issues later on, to be able to document your process to regulators, that's the best way to start to operate and protect yourself while we're in this space where, the law is kind of gray. You have guidance and you have this patchwork, but you don't have a very blunt force specific, you can do this and you can't do that. And that might be for the good. All right, we'll have to see how that all shakes out. And then finally, the end, being transparent and having consumer rights. So this is just a general overview of the life cycle. And on the next slide, we just have some questions. And there was a question about, access to slides. We'll try to make some of these available. And again, not going to read through all of these, but these are just some, questions you should be asking, like how do you start to put together, an assessment, for example? How do you start to assess not only your vendors, but your internal products? And, I think specifically understanding, because we have this patchwork, which laws apply? Are we deploying in Europe? And then we have this, very sophisticated regime, I think that we'll have in place at least by next year. Or we're in the US, we'll have to look at, a patchwork of existing laws, a patchwork of existing consumer protection laws and privacy laws and local laws that you have to govern. So understanding what that looks like and how that impacts you, thinking about things like vendors, unintended consequences, and then some of the audit tools. So again, don't want to read through all of this, but just wanted to have this out there. And like I said, we'll try to make this available just so you have some tools and resources as you're starting to build your programs out. So if we get to the next slide, I think we'll jump into ethical considerations. There's 4 minutes left to cover all ethics, which seems like an appropriate amount of time. So I'll hand it off to Caroline.
Yeah, we do want to talk a little bit about some of these ethical considerations because they do carry some real weight for us as lawyers. And I think with the little time we have left, there are even more questions I feel like to ask. Some of them are similar to the ones that we've been talking about up until this point, right? What's the purpose of what we're trying to do? But they also touch on, to the extent that we're dealing with specific individual people and personal data, and we have all these privacy and security considerations, we also have to think about, is this use case going to treat people fairly in order to achieve whatever goals and purposes we've identified as part of our overall sort of review process? Is the way that we're using this data to train the system and this purpose, is that all compatible for the context in which we got this data in the first place? And is it all generally consistent with our business values? So we have to look at everything we know about how this AI system or platform works, the data it's looking at, the assumptions that it's making, to figure out whether the outcome is going to be consistent with our goals and sort of our ultimate goal, right? At the end of the day, as privacy lawyers, we care about personal data because we care about people, right? And whether the outcome is going to be consistent with an ultimate goal of fairness to those folks. So very quickly, we wanted to touch on one example, one cautionary example. In this one, many US hospitals were basically using an algorithm to try to help make some decisions about how to allocate healthcare resources to patients. And the system was created and it was meant to help provide additional medical resources to people that had more complex medical needs, making sure those resources were getting allocated where they were needed. And instead, the system was ultimately providing white patients with more resources than Black patients. So there would be a Black patient and a white patient, they were equally sick, but the algorithm was less likely to refer the Black patient to a program that was aimed at improving care. And that was happening because the system was using healthcare expenses as a proxy for healthcare needs. So the more money that was being spent on a particular patient was used as a proxy for the amount of additional care that might be needed. And that correlation wasn't always correct. So the assumption that the system was making wasn't right. And I think all of that is just trying to make clear that these ethical considerations, especially when it comes to bias and discrimination, are extremely important because of the impact they can ultimately have on people. And the main takeaway, I think, at this point is just to try and put in some plans and some ways to recognize biases in data, biases that can be learned by AI systems. And that might not be obvious on its face. We have to deliberately test for it. We have to test for it in the data, the system, the outcomes, to try to combat some of these unconscious processes and address them with a plan. So I know we've been taking a look at the Q&A as we've been going to see if we'll take a look again now to see if we can address any other questions that have come in. Feel free to drop your question in the minute we have remaining, if it's just coming to mind for you now. If you don't have questions right now, but you end up with burning questions later, please reach out. We would love to chat with you more about questions this content brings up for you based on your business and your use cases. Here's the CLE code again, as promised. And I don't see any other questions that we haven't answered yet. So I will give it back to Brian.
No, that was great. Thank you all for joining, and thank you guys for participating. As we said before, if you'd like the recording of our prior webinar, just reach out. And this one, I think the recording will be distributed as well in the email confirmation. Thanks for joining, and we look forward to speaking to you again on a future topic.